Well, good evening once again. As I said earlier, my name's Kate O'Regan. I'm the director of the Bonavero Institute, and you're all very welcome to this, the inaugural Bonavero Annual Human Rights Lecture. And we're particularly delighted to have this panel of distinguished jurists to speak this evening. I'm going to leave it to Helen Mountfield QC, the principal of Mansfield College, to introduce our speaker and the discussant. But I just wanted to warmly welcome you on behalf of the Bonavero Institute, and to welcome our founder donor, Yves Bonavero, who I can't see here, but we're delighted that he's here with us this evening. I also wanted to say that today is the first day of a big university strike across the United Kingdom, which the Bonavero Institute is very conscious of. And we have taken a position at the Bonavero Institute to acknowledge the importance of equity within the higher education sector. At the Bonavero Institute, a significant number of the people who work for us are early career researchers, and there are serious concerns amongst the early career researchers about precariousness within the sector. And I think all of us who care about universities and the project of teaching, learning, and research that goes on at them needs to monitor the way in which these issues are resolved. At this stage, then, I'd like to turn to Helen to say thank you very much, but I should perhaps just say one of the great benefits for the Bonavero Institute in Oxford has been to be housed at Mansfield College. First, in many ways, we are the progeny, in a kind of way, of Helen's predecessor, Helena Kennedy, who raised the funds to establish the Institute. And now we're deeply blessed to have a human rights barrister of great standing in her own right to be the principal of the college, and it's a wonderful partnership which I think we feel is of mutual benefit both to the Bonavero Institute and to Mansfield College. Helen.
Thank you. Well, I'm not sure I need really to follow those kind words of introduction, but it is an enormous treat for me to call it work, to go to seminars at the Human Rights Institute, and this evening to welcome you to such an interesting and important debate with such distinguished speakers. We're very pleased in the light of the important and controversial debates which have arisen in the light of Lord Sumption's Reith lectures to invite so distinguished a judge of the European Court of Human Rights as Judge Spanó to give a response on the democratic virtues of human rights law. He will, I think, speak for about 45 minutes, and then Lord Sumption will be giving a reply, and I hope that I will be having an opportunity to take some questions and moderate responses from the floor. So it should be a very interesting evening. Thank you all for coming. Thank you all for waiting, and I'm absolutely delighted to welcome Judge Spanó.
Thank you very much indeed, Principal Mountfield. I begin, ladies and gentlemen, of course, by extending my gratitude to the Bonavero Institute of Human Rights at the University of Oxford and its director, Justice Catherine O'Regan, for inviting me to speak this evening. I want to say at the outset, and I want to be clear, I bring an external perspective. I will not be commenting on domestic political issues or developments in the British legal system. For that, I am not equipped. There are professionals in the room here who are much better suited for that debate. What I will do is I will begin by focusing in general on Lord Sumption's views on the expanding role of law at the expense of politics before engaging with his third lecture, which is entitled Human Rights and Wrongs, and his criticism of the European Court of Human Rights. I proceed in this manner as it is difficult to disentangle the third lecture from Lord Sumption's overall thesis. The 5 lectures must, in other words, fairly be read as a whole. When referring to his lectures, I will use the language Lord Sumption deploys in his published volume, entitled Trials of the State, Law and the Decline of Politics. In my intervention, I offer my personal views, which should in no way be ascribed to the court on which I serve. This evening, I will be taking issue with a number of elements in Lord Sumption's lectures. However, let me be clear. Broadly speaking, his thesis and the debate it has triggered is to be welcomed. A robust discussion on the trajectory of our societies and their normative functions is crucial for a community's sustained legitimacy and growth. Lord Sumption, an eminent British historian and jurist, Queen's Counsel, and former Justice of the Supreme Court of the United Kingdom, is particularly well placed to partake in such a debate. It is also a great pleasure for me to share the stage with him and Principal Helen Mountfield QC here this evening in the Old Hall at Lincoln's Inn. I will proceed in two parts, which will encapsulate my two central arguments, which are these. First, it seems to me that Lord Sumption underestimates the value of human rights law in legitimizing political outcomes in a democracy. He eloquently states at the start of his third lecture, and I quote, "Human rights is where law and politics meet, but counsels that this can be an unfriendly meeting." True, but incomplete in my view. Law plays an integral part in justifiably characterizing political action as democratic. In a state governed by the rule of law, the legitimate exercise of political power must always be regulated by the law. Law and politics are thus inextricably entwined in a true democracy. It is imperative to appreciate these premises of my intervention this evening. They form, I submit, the cornerstones of the convention system and the work of its court, the European Court of Human Rights. My second argument is this. Lord Sumption's description of the nature of the judicial process in human rights cases is to some extent misconceived. In particular, when it comes to the Strasbourg Court, his thesis, as I will explain, lacks a comprehensive and nuanced understanding of the historical development of the court and the convention system. As will be demonstrated when examining the jurisprudence of the Strasbourg Court, an appreciation of its history is crucial. I begin by examining Lord Sumption's general thesis in favor of more politics and less law. As I understand him, his thesis centers around his disapproval of the legalization, or in other words, the judicialization of the process of dispute resolution in society. He argues in his first lecture, Law's Expanding Empire, and I quote, "Rules of law and the discretionary powers which law confers on judges limit the scope for autonomous decision-making by individuals," close quote. In his second lecture, entitled In Praise of Politics, Lord Sumption argues that although majority rule is a basic principle of democracy, majoritarian decision-making is only enough to authorize state action. It is not enough to make them legitimate. That is because majority rule is no more than a rule of decision. This is one reason, he continues, that all democracies have evolved methods of limiting or diluting the power of majorities. He then considers two of them, representative politics and law. Lord Sumption claims that courts have come to share the general suspicion of the political process and of political reasoning as an element in public decision-making. They have developed a broader concept of the rule of law, which greatly enlarges their constitutional role. He then arrives at the core of his argument. He states that the judicial resolution of policy issues undermines the single biggest advantage of the political process, which is to accommodate the divergent interests and opinions of citizens. He concludes his second lecture with characteristic eloquence, stating the following, and I quote, "Litigation can rarely mediate differences. It is a zero-sum game. The winners carry off the prize, and the losers pay. Litigation is not a consultative or participatory process. It is an appeal to law. Law is rational. Law is coherent. Law is analytically consistent and rigorous. But in public affairs," he continues, "these are not always virtues. Opacity, inconsistency, and fudge may be intellectually impure, which is why lawyers do not like them. But they are often inseparable from the kind of compromises that we have to make as a society if we are to live together in peace." Close quote. I begin my response by making clear that there are many elements in Lord Sumption's overall thesis with which I agree. In particular, his distinction between the authority of majority rule, on the one hand, and on the other, the legitimacy of majoritarian decision-making in a democracy, is a posit. It is clear, as he correctly argues, that the authority of majority rule does not necessarily connote democratic legitimacy. However, his views on the nature and role of the judicial process in a democracy require a considered response. First, courts importantly promote the determination and upholding of rights in ways consistent with the constitutional ideal of legal and political equality. Legal adjudication and political debate are not mutually exclusive. They are complementary parts of an inclusive democratic structure designed to ensure that all individuals are treated with equal concern and respect. As Lady Hale stated eloquently in the 2004 judgment in the House of Lords in the Gaidan case, also referenced by Lady Hale in the 2013 Chester judgments on prisoner voting rights, democracy values everyone equally, even if the majority does not. This statement is fully in harmony with the Convention and the jurisprudence of the Strasbourg Court. Indeed, as recently explained extrajudicially by my colleague, the current UK judge Tim Eike, this inclusive view of the democratic concept has a long historical pedigree. Almost 40 years ago, the plenary of the Old Court, the Old Strasbourg Court, said the following in the famous judgment in Young, James, and Webster versus the United Kingdom, and I quote, "Although individual interests must on occasion be subordinated to those of a group, democracy does not simply mean that the views of a majority must always prevail. A balance must be achieved which ensures the fair and proper treatment of minorities and avoids any abuse of a dominant position." Close quote. It follows that although Lord Sumption is correct that compromise is often necessary for the furtherance of peace in a democratic society, political action in achieving such common solutions, which excludes the meaningful participation of marginalized groups or minorities, is anathema to a true democracy. Unchecked majority rule that takes no account of the interests of the minority risks descending into authoritarianism. In short, elections do not create omnipotence. Ladies and gentlemen, this is, I submit, the core of the democratic virtues of human rights law. Second, Lord Sumption pleads, as I understand it, in favor of a system of democratic majoritarianism, but one which attempts to limit the dangers of oppression by robust representative politics. He warns against a set of substantive rights being fixed in a manner that legally constrain political majorities, the substance of which are interpreted and applied by courts. But I ask, is this belief in the virtues of representative politics belied by past and more recent history? The answer seems clear. A society of rational human beings, a community of civilized peoples, can learn from their past failures, readily appreciate the foibles of the human condition. Society may have readily experienced that the opacity, inconsistency, and fudge of the political process, to use the word Lord Sumption favorably deploys to characterize its virtues, can carry with it grave dangers. European societies established a structure of constitutional democracy in which certain fundamental rights and values were given normative status limiting majoritarian rule. In this manner, they attempted to make the political process itself more rational, less prone to being dominated by gut feelings, by fear, anger, and hatred, all primitive human elements that have given life to populist and ultimately self-destructive tendencies. My third reflection on Lord Sumption's general more politics, less law thesis begins with the following question, which I allow myself to submit to you in rather blunt terms. Is this really the time in European history to place our bet on more politics and less law? To entrust our destiny to the existence of good faith in the political process and argue in favor of limiting the review powers of independent and impartial judges? Truth is, after all, a cornerstone of democracy. The fundamental premise of democratic politics is that societal solutions and communal compromises are adopted on the basis of some minimum set of shared values and the existence of objective truths. Does that premise hold true in contemporary political processes in our part of the world? I fear not. Nationalism, tribalism, dislocation, fears of social change, and the distrust of outsiders are on the rise again as people limited by their partisan silos and filter bubbles are losing a sense of shared reality and the ability to communicate across social and sectarian lines. No, I argue, it is not unjustified to claim that now is not the time for more politics and less law in the sense advocated by Lord Sumption. Just to be absolutely clear at this point, so my remarks will not be misconstrued or misinterpreted. By this, I do not speak of weakening the role of politics, but rather for law to continue to sustain its true and inclusive democratic character. By this, I also do not mean that pure policy issues and matters of high politics should be resolved in the courtroom. Far from it. But I do argue that in the age we live in, independent and impartial judges are quite fundamental for the sustained legitimacy of the political process and the separation of powers. This is not at all about judges seizing the policy agenda, as some have claimed. Of course, judges should not remake society. They have a modest role. They assist society in not losing sight of our consensus principles. Courts are primarily concerned with process, not substance, with how things get done rather than what is done. Judges are, in other words, oiling the democratic machine, not telling it what to produce. So in concluding this first part of my intervention, I submit to you, ladies and gentlemen, that one has to readily appreciate that the often uncompromising attitude of political actors is the totem of our current culture of clashing visions. Hence, and with respect, Lord Sumption's more politics, less law thesis manifests, it seems to me, an overly idealized view of politics, a view removed from the realities of everyday hardships, which, when they engender disputes, require resolution by independent and impartial courts applying methods of principle. This latter point brings me to my second part, where I address in more detail Lord Sumption's core argument related to the limits of the judicial process as a substitute for political compromise. I will in particular engage with his criticism of the European Convention on Human Rights and the Strasbourg Court, the subject matter of his third Reith lecture entitled Human Rights and Wrongs. Allow me to begin this second part by asking you these questions. How can politics alleviate the torment of parents searching for hope when they are told that their sick child is facing a certain death? Or resolve the fact-specific clash between the free speech rights of journalists and the privacy rights of public persons, the latter alleging defamation? Or further engage in the delicate balancing of interests implicated when the criminally accused faces charges on national security grounds whilst having to defend him or herself without access to evidence. Let me be clear, all of these disputes as they arise from the complexities of life's happenstance are not resolved by the judge on a blank slate. Of course not. Politics should set the framework in written statutes or other positive norms. Yes, the framework is often a value system based on compromise, promulgated into law. And in a democratic society governed by the rule of law and the separation of powers, this legislative framework sets boundaries for the judge, sometimes strict, often open to interpretation and the application of reasoned discretion with the aim of giving life to the legislative will. But in a democracy, the role of politics ends there. That is the point at which politics has done its job. It is not equipped to resolve live controversies. Politicians are not elected to be dispute resolution arbiters, applying the craft of the law on the basis of evidence and formalized and impartial procedures. In a democratic society, the meeting of law and politics is not necessarily unfriendly, as Lord Sumption claims. On the contrary, this meeting is both unavoidable and necessary for a democratic society aspiring to be governed by the rule of law to properly function and not explode into chaos. I make these points now as they are particularly salient when one examines the criticism leveled by Lord Sumption at the convention system and the Strasbourg court. The core of his argument is this: the Strasbourg court has adopted an interpretive method, in particular the living instrument doctrine, which does not respect the natural limits of the convention's text. In fact, he claims it has invented rights. It has interfered with national political processes in a manner which undermines democracy. It is guilty of mission creep. It interprets the convention in a manner that only provides, quote, very limited allowances for differences between the member states' moral values, their political cultures, or their institutional traditions, close quote. These are very strong words indeed. But allow me to begin with these words of caution. This debate, if it is to be useful and reasonable, not mere hyperbole, cannot be couched in black and white terms, an either or. Of course, the Strasbourg court, like any court, has at times arrived at results which can legitimately be criticized. But by some, it will be considered that the court will have entered into the realm of national politics. But one should be cautious in overstating the case. With great respect, Lord Sumption's thesis does just that. I argue that more depth is needed, a subtle appreciation of history, and a smidgen of nuance. To start with, let's turn to history, because when critically assessing the Strasbourg court, it is crucial. Indeed, an eminent historian like Lord Sumption will be aware of Justice Oliver Wendell Holmes's famous aphorism, "A page of history is worth a volume of logic." In other words, when analyzing methodological approaches applied by national and in particular international courts at the level of theory and principle, it is important to be mindful of their historical trajectories. As Lord Sumption points out, rights do not exist in a vacuum. The same applies a fortiori to courts, in particular in an international human rights court like the one in Strasbourg. When interpreting and applying the convention, the Strasbourg court has gone through 4 stages since its establishment in 1959. The first stage, the so-called diplomatic phase, occurred from 1959 till approximately the beginning of the 1970s, when the court was perhaps a minor player, composed mainly of statesmen, professors with diplomatic experience, the court not being considered a force to be reckoned with by the relatively small number of member states that had accepted its jurisdiction. Then things changed during the second phase, from the beginning of the 1970s until the fall of the Berlin Wall in 1989. This is the phase that some commentators have called the judicial phase. It is when the court formulated its main general principles, like the living instrument doctrine, the principle of autonomous interpretation, and the margin of appreciation, which are still applied today. Why did this happen? There are probably many reasons. Remember, at this point in time, the court operated in a European environment receptive to increased integration and cooperation between states. International organizations were viewed as catalysts for increased prosperity, and human rights became a true and independent legal discipline. Then, when the Berlin Wall fell in 1989, the court entered its third phase, the post-communist phase, with the convention system expanding dramatically to the east up and until the beginning of the new century. The court in between being drastically restructured with Protocol 11, the abrogation of the commission, and the establishment of the permanent court in 1998. The court was subsequently flooded with cases, and Protocol 14 was drafted. At the same time, we see that the European environment became less receptive to international intrusion in domestic affairs, but also that some domestic systems, and this is very important, like in the United Kingdom, had fully embedded the logic and principles of the Convention into their national laws and practice. Thus began the fourth and current phase in the life of the court, approximately with the start of the Interlaken process a decade ago. This is a phase in respect of which I coined the now often used term, the age of subsidiarity, in an article published in 2014. In the last decade or so, the court has to a considerable extent recalibrated the methodological parameters of its jurisprudence towards a more democratically incentive review mechanism. When national authorities have in good faith balanced competing interests, in other words, themselves adequately assessed the necessity of an interference into qualified rights, the court is increasingly ready to apply the rule that it will require strong reasons for it to substitute its judgment for the one adopted by the national authorities. There are many examples of this subsidiarity-based approach in the case law of the Strasbourg Court, and with respect, none of which are referenced by Lord Sumption. Let me take just one, the judgment in the case of Ndidi versus the United Kingdom of 2017, a case dealing with the rights of immigrants, an area of the law which has often been the subject matter of criticism directed at the court in this country. A Nigerian national complained that his deportation from the United Kingdom would constitute a disproportionate interference with his right to respect for his family and private life, under Article 8 of the Convention, a provision to which I will return in a moment. The court found no violation of the Convention. It opined that the margin of appreciation has been generally understood to mean that where domestic courts have carefully examined the facts, applying relevant human rights standards consistently with the Convention and the court's case law, and adequately balanced the applicant's personal interests against the more general public interest, it would not be for the Strasbourg Court to substitute its own assessment of the merits for that of the competent national authorities. The only exception to this is where there are shown to be strong reasons for doing so. It is true that in his published volume of the Reith Lectures, Lord Sumption adds a paragraph not included in his initial public speech, stating, and I quote, that in the last 10 years, the Strasbourg Court has undoubtedly become somewhat more sensitive to the political implications of its decisions and less aggressive in its expansion of convention rights, close quote. However, it seems to me that his overall criticism and core arguments directed at the Strasbourg Court unfortunately failed to adequately take exactly this historical development into account. Lord Sumption focuses his substantive criticism of the court's jurisprudence mainly on Article 8 of the Convention, the right to privacy or private life, and on the living instrument doctrine. He explains it, and I quote, as a process of extrapolation or an analogy, so as to reflect the court's own view of what additional rights a modern democracy ought to have. The court, in other words, resorts to the living instrument doctrine to declare rights which are not in the Convention. He concedes that some development of the text is unavoidable when applying an abstract statement of principle to concrete cases. In addition, some concepts in the Convention plainly do evolve over time with changes in our collective values. But he concludes the Strasbourg Court has gone much further than that. In support of this conclusion, he compares in his fourth lecture, entitled Lessons from America, the court's case law under Article 8 with the US Supreme Court's substantive due process doctrine. Ladies and gentlemen, these arguments are, in my view, and again with respect, problematic on several levels. First, let me immediately dispose of the inapposite comparison Lord Sumption makes between the US and European models, and in particular his reference to the use of the substantive due process doctrine in American constitutional law. The US Constitution, the Bill of Rights, does not, I repeat, not encompass a textually based right to private life. The European Convention on Human Rights does quite explicitly. This is a fundamental difference of principle, a difference not readily appreciated in Lord Sumption's lectures. The European states that have signed and ratified the Convention, including the United Kingdom, have done so in the full and complete knowledge that they are incorporating a legal right to private life into their domestic legal systems, a right they were also perfectly aware would be interpreted and applied by the Strasbourg Court. Second, Lord Sumption claims that the right to private life under Article 8 of the Convention was, and I quote, designed as a protection against the surveillance state in a totalitarian regime. It surely was. But on what basis can he reasonably claim that the purpose of this provision was only limited to surveillance activities? That conclusion can certainly not be derived from the text of Article 8, which makes no reference to such activities. In fact, by making this claim, Lord Sumption is himself normatively interpreting the concept of private life within Article 8, engaging in the type of process of extrapolation from the text which the Strasbourg judges and national judges are required to perform. But on what basis can it then convincingly be argued that the way in which the court has interpreted the right to private life is legally erroneous or indeed overly expansive? Expansive in what sense? The text only refers to the concept of private life. There is no other explicit textual limitation as to the scope of the right in the terms of the provision itself. That is the text formulated by the drafters and subsequently adopted and ratified by 47 member states of the Council of Europe, including the United Kingdom, which moreover enacted the Convention into law with the Human Rights Act in 1998 coming into force in 2000. In other words, viewing the broad manner in which the Convention guarantees are worded, it is quite difficult to fully grasp what is meant by the claim, also propounded recently by some others, that the court has in select judgments, and I quote, brazenly departed from the terms of the Convention. Indeed, those like Lord Sumption who argue that the Strasbourg Court has interpreted Article 8 too broadly have themselves adopted their own viewpoint of how that concept should be interpreted. Clearly, their viewpoint has to then be normatively justified on the basis of legal arguments which, when it comes to Article 8, cannot naturally be limited to the mere text of the provision. Simply saying that the Strasbourg Court has gone too far, strayed from the text, invented rights, is with respect unhelpful rhetoric, unless it can justifiably be supported by a normative framework of interpretive analysis based on the Convention's text, structure, and history. Although Lord Sumption's lecture were, of course, not meant to be an exhaustive treatise on these issues, one is unable to identify in his lectures cogent analytical elements substantiating his criticism. However, I respectfully submit that a careful, comprehensive, and historical analysis of Strasbourg case law will easily uncover such arguments. One may then agree or disagree with them, but they are there. At the end of the day, one gets the sense that in substance, some of the Strasbourg Court's interpretive outcomes under Article 8 of the Convention are not to Lord Sumption's liking, but that cannot alone and justifiably sustain the criticism he levels at the court. There is an important element of interpretive principle in play here that those, like Lord Sumption, fail perhaps to appreciate fully when it comes to the court's interpretation and application of the Convention's so-called qualified provisions, Articles 8 to 11. These provisions require a convincing demonstration by the member state that an interference with a right was necessary in a democratic society. Lord Sumption correctly states that the Strasbourg Court tends to give a wide scope to the rights protected by the Convention, and that it does so precisely in order to require more and more legislative and governmental measures to be justified in court. However, he seems to view this as a negative side effect of the Convention system. There are two salient points worth mentioning here before I conclude. First, it is true that the court's jurisprudence has certainly not given a narrow reading to the abstractly worded rights in the first paragraphs of Articles 8 to 11. But that does not necessarily mean that it is correct to claim that the Convention's scope of protection, I repeat, scope of protection, can in all instances be characterized as expansive. Analyzing whether a complaint falls at the outset within the scope of applicability of a Convention right is certainly an important methodological step in the analysis. That is clear. However, when assessing whether the Strasbourg Court's findings constitute in the aggregate an overly expansive view of the reach of the Convention and its impact at national level, it is the final outcome of the assessment which matters. It is the end result that counts, not the starting point whether an interference has occurred. For example, on issues like sexual orientation and identity, Article 8 protections are indeed robust, but in others they are quite limited, like in cases dealing with foreigners' rights and other migration issues. Lord Sumption explicitly refers to the issues of abortion, medically assisted suicide, and fetal tissue research in his lectures. He argues that in a democracy, the appropriate way of resolving such disagreements is through the political process. I couldn't agree more. On abortion, on medically assisted suicide, and on fetal tissue research, the European Court of Human Rights has said very little or absolutely nothing. It is because this has been left to the states. Ever since Purdy versus the United Kingdom in 2002, up until Lambert versus France of 2015, the court has explicitly stated there is no right to assisted dying under the Convention. There is no European consensus. This is for the member states. On abortion, the court's jurisprudence has been similar. And when it comes to issues of fetal tissue research, again, Evans versus the UK, cases like Paria versus Italy, all demonstrate an ample, wide margin of appreciation where the member states' own moral and political traditions are decisive. This brings me to my second point. As I mentioned a moment ago, Lord Sumption seems to view it as a negative side effect of the Convention system that legislative and governmental measures have to increasingly be justified before a court of law because the scope of rights is broad. I respectfully disagree. In a constitutional democracy that is true to its name, requiring the political and executive processes to produce rational and reasoned justifications for intruding into people's lives is in itself inherently democratic. As I have argued, when individual disputes arise, a democratic society resorts to independent and impartial courts to settle the matter, which must then take into account the justification deployed by the legislative and executive processes. As I explained at the outset, courts, including the European Court of Human Rights, thus in fact promote and incentivize the democratic process. In other words, they attempt to encourage a symbiotic relationship between politics and law, manifesting in practice the democratic virtues of human rights law. Ladies and gentlemen, whether you agree or disagree, I hope I have managed throughout my intervention this evening to convey to you the fundamental idea that politics, by its nature, does not in principle provide individual justice. Politics do not provide for a sober and principled decision-making process which delicately balances often incommensurable and contradicting values that inevitably come into play by individually lived events. Yes, politics produce generally applicable norms promulgated in legislation. Politics is capable of providing a democratically legitimate framework and a forum for compromise for competing values generally accepted by the polity. But in a democratic society, independent and impartial judges are entrusted with fairly interpreting rights and values when they are triggered by concrete controversies between the state and its peoples, or indeed between private individuals resulting from the vagaries or indeed the tragedies of everyday life. Again, ladies and gentlemen, this is not the age in our common existence to call into question the importance and utility of law, to rely solely on politics for social justice, for the protection of human rights, and for lasting peace and security. So whilst worthy of considered debate, Lord Sumption's thesis is ultimately an ode to a bygone era, a period of human history that has thankfully passed and one which we should not awaken anew. As argued cogently by Professor Samuel Moyne in his book, The Last Utopia, Human Rights in History, in the days of old, the point of rights was not to restrict the activities of the state by providing a courtroom forum for their protection. Instead, the main remedy for the abrogation of rights remained democratic action, up to and including another revolution. Ladies and gentlemen, in my view, we should not again contemplate that extreme recourse. However, to be fair to Lord Sumption, his lectures should not be read as an invitation to strip the courts of their power of judicial review, or of the power to determine whether human rights have been violated. But at its core, the problem with his more politics, less law thesis is in fact this natural and indeed fundamental concession. Because once that concession is made, it all boils down to a line-drawing exercise between law and politics. And then we must continue to rely on and strengthen the collaboration between politicians, the community, and independent courts. That requires an acceptance of the strengths and weaknesses of the separation of powers, the acceptance of the human reality that judges may get it wrong from time to time, that although one may validly disagree with individual judgments, the fundamental values of a system of constitutional democracy and the rule of law are indeed worth the occasional unfriendly meeting between law and politics. To conclude, I respectfully submit to you that this is the overarching idea that animated the construction of the convention system and has since guided the jurisprudence of the Strasbourg Court. It is a jurisprudence that does not weaken the political process, but in fact seeks to empower it. It is a jurisprudence that readily accepts that politics can't thrive without law, as law forms an integral part of the political fabric of a democratic society. If law's empire is expanding, as Lord Sumption claims, it is not at the expense of politics. On the contrary, law, in particular human rights law, morally sustains and strengthens the political process in a true democracy governed by the rule of law. Together, law and politics should seek to work hand in hand in creating stability and a humane society which respects rights and human dignity. Correctly understood, each has their proper role, and their work is mutually reinforcing. In short, one cannot survive without the other. Thank you very much.
I think the starting point really is a basic and a philosophical one. I do not accept that there are rights which are inherent in our humanity and which can exist apart from institutional choice. Rights are the creation of law, which is a product of social organization. And the problem about all arguments which suggest that there are, in some way, inherent rights that courts applying their reasoning are in a uniquely well-favoured position to discover is that they overlook what seems to me to be the basic purpose of law. The purpose of law is not to formulate moral ideals. It's to accommodate divergent interests and opinions among highly imperfect and generally self-interested human beings. In order to do that, those human beings have to accept the legitimacy of the process that leads to these decisions. I do not see how that can be achieved unless societies have institutions for the giving of consent to the laws. And the laws, whatever their origin, whether legislative or judicially created. Rights are claims against our fellow citizens, and in a democracy it seems to me to be entirely fundamental that they require an institutionalized process of consent. Human beings are entitled to make, and in practice do make, different choices about such things. Now, I do not object, when I speak of human rights, to the rights themselves. Some of the rights, which are now classified as human rights, have been recognized by the common law or embodied in domestic legislation for much longer than we've had a Human Rights Act. Others are, in my opinion, desirable. What I object to is a particular method of recognizing rights. I object to the role of domestic and international courts, first of all in developing and expanding human rights, and secondly, and crucially, in deciding when it is legitimate to override a human right in some wider public interest, such as public safety, public health, and so on. Both of these things have been happening, it seems to me undeniable, on a significant scale. The European Court of Human Rights in Strasbourg has developed and has accepted in its doctrines that it has developed a highly expanded field of human rights. It has devised a vast range of what one might loosely call ancillary rights, which are not in the Convention, although they may well be desirable. Now, many of these rights are controversial, but many of them are in no sense fundamental. And the Strasbourg Court, enthusiastically seconded by the domestic courts, has asserted that the question when other public interests should prevail over a human right is a question of law, and therefore within the purview of courts of law rather than institutionalized consent. Sometimes this is very explicitly stated, as it was in some of the later decisions on voting rights of prisoners in the United Kingdom, when the Strasbourg Court dealt with the suggestion that this had acquired democratic legitimacy as a result of its acceptance by Parliament. It simply said, it's a question of law and therefore not Parliament's business. Now, the effect of the recognition of human rights on that basis is to remove issues which may be highly controversial from the ordinary process of democratic decision-making. And my objection to it is that this has no democratic legitimacy. It is not founded in any kind of consent. The object, after all, of human rights law is to create a body of law with a privileged status, something which cannot be overridden by the ordinary constitutional processes of the state. And the motive behind this, as I think Judge Spanó has implicitly accepted, is a distrust of democracy and of democratic majorities, because they can, in extreme cases, do terrible things, and have done in the 20th century. We all know this. Now, a democracy can have whatever rights it wants. It can enact legislation creating whatever rights it wants. But the object of human rights law is to insist that there are some rights which a democracy must have, whether it wants them or not. And the problem about that is that if you are going to set up a body of principles which prevails over democratic choice, you have to ask yourself the question, what is it that makes those principles legitimate, if not democratic choice? Now, in a world which no longer believes in God-given rules, the only possible source of legitimacy other than democratic choice is the notion that some rights are so obviously just that democratic choice should not be able to oust them. What then if people disagree about that? Suppose hypothetically that I believe that there is or ought to be a right to medically assisted suicide, or a right not to be extradited to countries where one might be sentenced to death, and suppose that you disagree with that. If a majority of my fellow citizens is on my side, then how are we going to resolve that disagreement otherwise than by a democratic process involving some form of institutional consent? Now, I think a believer in human rights would say that democracy should be limited by certain values. But what makes it legitimate that those values should be my values rather than yours, or should not be the values of a majority of citizens in a democracy? Ultimately, those who believe that there are values which should prevail over democratic choice are driven to say that some people's views, in this hypothetical case mine, should be imposed. Now, the basic idea behind international human rights law is that there are some ideas that are so fundamental that they are beyond or above legitimate political debate. The more that the European Court of Human Rights moves into areas which generate legitimate differences of opinion, the less convincing that case becomes. If there is room for reasonable people to disagree about the existence or extent of some right, then it cannot be above legitimate political debate, except possibly in a totalitarian dictatorship. We have, I think, to accept this, because otherwise we simply cannot live together in a single political community with other people of diverse interests and opinions. Now, Judge Spanó asks, is this the time to be trusting our fellow citizens not to resort to extreme solutions? My answer to that is, yes, it is. And I will try and explain in the course of a few minutes why. But if I can return to the theme of consent, the critical area, and the area which I think provides the harshest test for the current regime, is the area which concerns exceptions and qualifications to convention rights. The whole process involves the weighing of one public interest against another. The incommensurate public interests have to be weighed against each other, and that I consider to be an inherently political and legislative process rather than a judicial one. Let's take the example which Judge Spanó gave, the right of privacy. The keeping of records by the police or the security services has been the subject of many recent decisions of the Strasbourg Court. It's been held to be covered by the right of privacy conferred by Article 8, but in practice, the argument is almost invariably about whether it is nonetheless justified by some competing public interest, usually public safety. Now, successive decisions of the Strasbourg Court and the domestic courts have taken a restrictive view of the exceptions. They have severely restricted the right of the police and the security services to retain DNA records, to monitor internet or mobile phone contacts, to photograph people demonstrating in public streets, or to keep personal files on people. Now, some of these decisions have significantly inhibited their ability, the ability of the authorities to protect or to defend or to detect or prevent crime. Now, this, I'm not expressing any view about which is the better side of this argument. The point that I'm making is that this is a classic public policy dilemma. How much privacy are we prepared to sacrifice in the interest of detecting actual or potential crimes which undermine our security? And there are a variety of opinions about this, all of which can legitimately be held. There are single-issue pressure groups which come close to regarding privacy as an absolute value, interference with which cannot be justified by any considerations of public safety. There are others who think that we should be prepared to submit to any amount of intrusion which may make us safer. I suspect that most of us inhabit some ground between those two extremes. But the point about this is it cannot properly be regarded as a question of law. It is something on which we disagree among ourselves. We need a political process to resolve that difference. And the result will not necessarily be the same in, say, Germany, with its difficult recent experience of the police state, as it would be in Italy, which defeated the Red Brigades in the 1970s, largely by highly intrusive methods of surveillance. These things are extraordinarily sensitive to public sentiment and historical experience, and to institutional standards and national culture. Now, Judge Spanó is, I think, suggesting, I hope I'm not misrepresenting him, that politicians are a less suitable group to be deciding such issues than judges. I simply do not accept this. Representative politics represents differences, at any rate, if they are sufficiently strongly felt among the general population. I think that for short periods, it is perfectly possible for a political consensus to emerge around a thoroughly repellent and extreme position. Over the longer term, I do not think that this is possible if politicians wish to be re-elected. And in the end, I don't believe that the extreme position is ever likely to be sustainable unless the advocates of it actually suppress the democratic process itself. Now, the argument against entrenched rights, which one hears most often and which was prominent in Judge Spanó's discussion, was that they are necessary to protect minorities. Most questions, not all, but most questions involving the protection of minorities are questions of discrimination, whether by public authorities or by private persons. We have a perfectly adequate system of domestic laws to protect minorities from discrimination, and we've had them for much longer than we have had a Human Rights Act. Minorities have votes, and historically I think that Parliament, in fact, has a good record for protecting them. Most human rights, however, have absolutely nothing to do with the protection of minorities. Freedom of thought and expression may sometimes protect minorities. Freedom of religion usually does. But if we take the most heavily litigated human rights, such as the right of privacy or the right to a court, these are concerned with the entrenchment of values which are wholly unrelated to the protection of minorities. They affect everyone. There is, of course, a broader concern which extends beyond the protection of minorities, and it relates to what is called majoritarian tyranny, the abuse of parliamentary majorities to ride roughshod over the sensibilities of others. Now, I acknowledge that this is a problem. It always has been. It's inherent in democracy. Any controversial measure will have been opposed by a minority, which may regard it as immoral or even oppressive. But the political process is, in fact, the only possible protection against that. The function of the political process is not just to arrive at a decision, but to accommodate dissent, something which it has historically been remarkably good at doing. Politics doesn't always do it well. It's not doing it very well, in my opinion, at the moment. But courts of law are completely impotent to deal with majoritarian tyranny unless they assume general legislative powers in place of the elected legislature. And on that footing, we are not entitled to call ourselves a democracy. Now, there are countries where racial or religious minorities are consigned to permanent opposition or where interests cannot be heard in the democratic process. We have heard from Judge Spanó references, which must be in all of our minds, about some of the extreme political regimes of 20th century Europe. If I lived in one of those places, I might well be in favor of a broader range of entrenched rights than I am. If I thought that my fellow citizens were monsters of prejudice and persecution, I might well be in favour of a broader range of entrenched rights. But I don't think that. In my view, it is legitimate to ask, what, if any, entrenched rights are necessary for our society in the United Kingdom as it actually is? The answer to that question will not necessarily be the same in other societies. Equally, I confess to being unimpressed by suggestions that the actual results of human rights law have created hope and pleasure in many people. I think that is true, they have. But this is essentially the argument that the end justifies the means, and it's the argument of every despot that has ever lived. Look, they say, at the excellent things that we have done, which all those argumentative politicians would never have done for themselves. And I would answer that with 3 short points. First of all, there is no right recognized by the Strasbourg Court which cannot equally be conferred in ordinary domestic legislation if there is a sufficient democratic appetite for it. Secondly, to say that judges make good law begs the question, what is good law? And that is a question on which citizens may properly differ, and the answer seems to me in a democracy must embody some form of consent. Thirdly, to say that the rule of law, that a rule of law originating in a judicial decision is a good sort of rule to have, begs the question whether it is so fundamental that we should have it irrespective of collective choice. I think it is fundamental that we have to distinguish, in a way in which I fear the Strasbourg Court has not always done, between a human right and something which is no more than a good idea. We may like some of the laws that the Strasbourg Court and our own domestic courts have made, but we should not be indifferent to the way that they are made. And if there is one theme which I certainly hope is fundamental to the Reith lectures that I gave, it is that the way that we make law matters very much and not just the result.
Thank you. Well, I would like to thank very much Judge Spanó for that very interesting and nuanced and historically informed analysis of the scaffolding role which law can play in upholding a democracy, and Lord Sumption for his equally thoughtful and customarily eloquent response. I'm sure it will have generated a large number of thoughts among members of the audience, and we have got time for some questions, so I'm going to ask people if they would like to raise any questions or make any observations in support of or against some of the views expressed. I can see a hand here.
Thank you very much to both speakers. My name's Dr. Alice Donald. I'm a lecturer at Middlesex University. I really want to address a question particularly to Lord Sumption, if I may, and to respectfully suggest to him that the terrain on which he's arguing is misconceived and indeed insular and even parochial, to the extent that he's considering the value of the Convention as a regional human rights treaty to the UK alone. I think that this kind of talk is immensely damaging in ways that don't seem to be appreciated to human rights defenders, to victims of human rights, to those seeking to further human rights standards and interpretation elsewhere in the Council of Europe. And I wonder what he would say to human rights defenders from Russia, from Azerbaijan, from Georgia, from Ukraine, for whom the Strasbourg Court is the last hope of justice, to be so insouciantly seem to throw away that benefit of a supranational regime, a regime in which the nations of Europe are seeking to set common human rights standards and to interpret human rights in a way which furthers the promotion of rights across the continent. It just seems to me incredibly insular and irresponsible, if I might say so, to be arguing simply for the, whether rights make sense in our UK context, without looking at the kind of common project behind the European Convention, which risks being undermined so disastrously if Lord Sumption's views are taken to their logical conclusion?
It is insular, but it is not. I forget what the rude word you used was. No. I would accept the accusation that it involves a measure of insularity. As I said, if I lived in Russia, I would probably take a different view. But it seems to me that one is entitled to take a view about the well-being of the society in which one lives. In my case, the United Kingdom. I do care about the well-being of other countries, but the problem about democracy, at least as matters presently stand, is that it is inherently national. We are a democracy within the United Kingdom. Our institutions are designed to produce something that is as acceptable as it possibly can be to the population of the United Kingdom. I care more about things that I can do something about and that my fellow citizens can do something about than I do about countries which I can do absolutely nothing about, much as I may sympathize with those who are the victims of oppression. As I understand it, the issue in the Julian Assange case is simply, under English law, whether he has committed an offence under the US law that has a corresponding paradigm in the law of this country. I happen to think that the disappearance of most of the discretionary elements in our extradition law in 2003 was a serious mistake, and I also think that there is no country to whom we extradite people whose practices illustrate how mistaken it was more than the United States does. However, the current position is perfectly clear, and I do not see what human right would be infringed if Mr. Assange were to stand trial in the United States for an offence which, had he committed it in England, would have been triable here.
You say that the removal of discretion is, in your view, a mistake, but the granting of discretion to a judge, on your analysis, might have been anti-democratic, because the judge would have had to apply some standards of his or her own to decide that question, and the legislature took that decision.
I don't object to all judicial discretion. Before 2003, the discretions were mainly exercised, in fact, by the Home Secretary, rather than by the courts. And part of the motivation behind the 2003 Act was to spare the Home Secretary that obligation and to transfer it to courts. Now, there are some circumstances in which, particularly those affecting individuals, where I wouldn't have any particular problem of principle about the notion of courts exercising a discretionary jurisdiction like that. But at the moment, there has to be an identifiable infringement of somebody's human rights involved in extraditing somebody in order to prevent it happening. We have an extradition treaty with the United States, which is entirely, very heavily one-sided, which effectively, subject to human rights infringements, gives the United States a right to extradition on demand. I think that is extremely unfortunate. If somebody were to suggest to me a human right which would be infringed, I'd be happy to consider it. But the reality is that he is not going to be executed in the United States, which is the concern that he has expressed for quite a long time. And even if it were an executable offence, the undertakings which are normal in these cases would protect him from that fate. I do not know of any other human right that might be infringed in his case, given that I think that in the United States the courts apply perfectly fair criminal procedures.
But isn't your argument that it shouldn't be a matter for you? Suppose he would be extradited, the legislature thought it was fine, they wanted that with the states, and he would be executed. Why is that anything to do with the judge? Why should it be anything? Why could it ever properly democratically
What
be
I
anything to
object
do with the
to
judge?
is the way in which human rights law enables judges to legislate. If a judge is deciding whether a particular individual should be extradited to the United States, I see absolutely no reason why he should not exercise a discretion if the law gives it to him, and I see no reason why the law shouldn't give it to him. The difference is that he is not exercising a legislative function. What he is doing is simply applying a discretion that has been conferred upon him without actually stating any proposition of law, let alone a new one.
May I, Helen?
Yes.
I think the point just made now by Lord Sumption, I think, is absolutely crucial. There is no disagreement on this table between the two of us that judges should not be legislating. That proposition is, for me, unquestionable. The question is, however, what does that mean? When the proposition is made that there is a distinction between the interpretation of a human rights norm, which is set and fixed in a statute, in a constitution, or in an international treaty, on the one hand, and there is an interpretation of that text to a set of facts, on the one hand, and there is some element of discretion which that involves, and another type of judicial activity which is called legislation, which is not proper, not legal, not possible for a judge to be engaged in. The boundaries between those two propositions, one has to be clear on. The problem I have with Lord Sumption's argument is, when he says, I don't accept judges legislating, I mean, there is no controversy about that. The problem is, where do you draw the line? And to make the claim in general terms, without having a proper delineation between where reasoned discretion and interpretation, which is justified, occurs, and where the judge enters into the legislative fora, can be a very difficult proposition to sustain, because it's a line-drawing exercise. And at the end of the day, is it for the politicians to make a determination where that line is drawn, or in a constitutional democracy where you have the separation of powers, where you do entrust judges with deciding disputes, that line has to be drawn, and I think you've said this also publicly, with judicial attitudes respecting the adequate boundaries between the separation of powers. But there is no magic formula for that distinction.
Can I just say that this thing about deciding disputes, I think that the expression is being used far too generally. There are disputes between private individuals, garden fence disputes, anything like that, which are obviously and exclusively a matter for judges to decide. On the other hand, disputes about the choice between competing public policies are essentially disputes of a constitutional nature. And in that context, I think it is completely different and quite unacceptable to say that simply because citizens disagree about a matter of public policy, the dispute resolution function of a judge is appropriate. I don't think that it is.
There's a hand here.
Thank you very much. Richard Millett. I'm Queen's Counsel who professes to know nothing at all about human rights. This is a question, perhaps two questions for Lord Sumption and a question for Judge Spanó. So far as my question or questions for Lord Sumption are concerned, is one of the problems the way in which the question has been framed? You speak of invented rights, but is that really right? Is it not, in fact, or is a right simply not an outcome legitimated by a very broad concept enshrined in a text adopted consensually by a society such as the society that existed at the very beginning of the Blair government in the spring of 1997, which created the Human Rights Act 1998. So it's a consensual act. The fact that it's broad is neither here nor there. And in the end, are you not muddling rights on the one hand with outcomes in individual cases on the other? So that's the first question. The second is it right to say that rights are simply claims against fellow citizens? In fact, as you've just said, I think, they more often manifest themselves as claims by individuals against states, and more particularly the executives of the states, who are not our fellow citizens in any real or tangible sense of the word. And that distinction seems to me to be one which is bedeviling the debate. Judge Spanó, I just wonder whether you've got off to a rocky start by saying that human rights are really there to protect minorities, and in fact whether really the better point might be that they're there to protect the autonomy of the individual, a legal concept which emerged after the Second World War, in fact, and has its origins long before that, certainly in this country. And at one and the same time, perhaps not to recognize the fact that in Europe, certainly during the more aggressive phase of the development of the court in the 1970s, as you pointed out, there was a strong distrust of democracies, which in many cases were emerging from dictatorships, such as in Greece and in Spain, and also an enduring love for elites. An enduring adherence to or love for elites. Those are two long and perhaps complicated questions, and I'm sorry to take time over them.
You're, of course, right to say that the Human Rights Act was adopted in the ordinary constitutional way in which any legislation is adopted. And Judge Spanó was right in his address to point out that at that time, many of the tendencies, indeed all of the tendencies, which I have been criticizing were manifest. But I think that there is a difference between a legislation which, in however broad terms, determines what the law is to be, and legislation which confers a right on a court or on any body standing outside the constitutional framework of the United Kingdom to determine what the law is or ought to be. Every time that the Strasbourg Court says that a statutory rule in the United Kingdom is incompatible with the Convention, and Parliament is faced with the necessity of changing it if it is not actually to withdraw from the Convention altogether, it is essentially deciding that the law ought to be something different from what statute, as the supreme source of law in this country, says it is. Now, there is, I think, a very real difference between a dynamic treaty which creates a method of deciding what the law is to be in future and a traditional form of legislation. My own view is that the Convention, if interpreted in accordance with ordinary principles of interpretation that apply in international law and are embodied in the 1969 Vienna Convention, would have led to a much narrower scope for human rights than the Strasbourg Court has awarded itself. Now, turning to your point about citizens against the state, I accept that there is a difference between cases where the citizen is against the state and the case where the citizens are against each other. It's a question of how one classifies human rights law. I think that human rights law embraces both categories, but it is actually far more significant in its resolution of disputes between different groups of citizens. I think that the illustration which I gave, and one could choose others, of privacy versus security is a very good example of this. Of course, whenever somebody is complaining that his right of privacy has been infringed, what he is saying is the state is oppressing me, I am a citizen, I am standing up for my rights as against the state. But in this case, and actually in most human rights cases, there is a much broader consideration, which is what ought the rule to be about the intrusive powers of the security services or the police. Behind every case in which somebody is saying, I have been oppressively treated, there is a wider principle about what degree of intrusion is legitimate. And so I would not accept your argument that this is basically about citizens versus the state. I think that in a relatively less important sense it's about that, but almost all of these cases give rise to broader questions of principle, which are fundamentally matters for democratic debate.
As to your question, you're of course absolutely right in making the distinction between the autonomy of the person and minorities as being both relevant within the context of human rights. And I think it brings us to one of the problems with a debate like this, and that is the use of concepts. It is very misleading to talk about human rights as a unitary concept. Human rights, this, human rights, that. There are multiple human rights. Human rights are, some of them, Article 8 of the Convention, the right to private life, encapsulates the autonomy of the person, according to the case law of the court, as also applied by national courts. So within that context, it is less a question of, and I fully share the views expressed by Lord Sumption, there are only certain types of human rights which have as their purpose or directly affect the status of minorities. But the reason references to marginalized groups or minorities was a salient or focus point in my first part was that I was trying to demonstrate the importance of an inclusive democratic concept. It is very dangerous to think about democracy as a purely majoritarian concept, which retains its legitimacy from the simple fact of majority rule. So that is in that context which I use the references. But of course you're right, there are multiple manifestations of the way in which human rights of a different character would implicate or protect segments of society. If I may, and I promised I wouldn't enter the British debate, but let me just say this. I think, with respect, it is quite simplistic to say or oppose as a matter of legal principle the situation in which the UK Parliament is confronted with a judgment of the European Court of Human Rights which requires Parliament to take a decision on whether it maintains a policy in a law considered to be not in conformity with the Convention, or whether it decides to change, for the following reason. It was the UK Parliament, and I know this is not an argument which is going to persuade Lord Sumption, but it was the UK Parliament itself that took the decision in 1998 to make the Convention and the principles of the Convention UK law. The Human Rights Act contemplated exactly the situation in the future in which the UK Parliament would be confronted with the situation just referenced by Lord Sumption, which is jurisprudence of the Strasbourg Court having the effect of the national courts declaring national law incompatible with the Convention. All of this was absolutely foreseeable and transparent. To say now, 20 years later, that there is something inherently undemocratic with the democratic decision of the UK Parliament envisaging that exact possibility as being one in which Parliament would be confronted with, and considering that the whole edifice of the Human Rights Act must crumble because of that inconsistency seems to me, to put it mildly, to be a bit simplistic. It is always, and not only for the UK Parliament, it is for any national parliament of the Council of Europe to make determinations how and to what extent they have to deal with jurisprudence from the Strasbourg Court. And that brings me to my final point, which is the point raised by Professor Alice Donald here at the outset, which is a crucial point. Let's go back to 1918 and post-First World War Germany, which was called the Weimar Republic. It is true that we could have had professors of law and judges in 1918 which would have said, we only think about internally how our democratic structure develops. But the teachings of the Second World War were that the insular view, the view of only looking at the way democracy evolves in our own countries without taking account of neighboring developments, the way collective guarantees and the unity of purpose in human rights law permeates the region in which we live, can have extremely damaging consequences. So it is the bubble of nationality which is the core purpose of the convention. Now, of course, if one takes the view that one should only be thinking about the development in one's own legal system, well, then one is ideologically opposed to the convention system's raison d'être as such. The starting premise there is one which cannot, in the long run, be sustainable. It seems to me that with the Human Rights Act, a decision was taken that the development of the UK constitutional order would, to some extent, within the realm of what Parliament would decide at any moment, be taken within the context of a collective view of how human rights should develop at the regional level. Now, here I fully agree. Those are two ideologically diametrical positions as a starting point.
Can I just say, I entirely agree that what has happened was foreseeable in 1998 and indeed was intended. But I don't think that that is actually an answer to the dilemma. If Parliament cedes the power to another body to make law, then it seems to me to be legitimate to ask whether the method of making law which it has authorized is itself democratic.
I'd like to give you all a chance to exercise your rights to private life, broadly expanded, to have a drink. But I just wanted to start off by thanking, first of all, Cato Regan and the Bonavero Institute of Human Rights for organising such an important and timely debate. I think it is very important for us to hear a multitude of voices in this very worrying historical moment when there are those who are anxious about the usurpation of the legislative role by judges, and also very many people who are anxious about the usurpation of the legislative role and the potential destruction of a proper functioning democracy defined as as Judge Spanó did by the executive purporting to act as the legislature. These are very important debates. It's why the Bonavero Institute exists. It's why I have the best job in Oxford, because there are debates like this every week in the Institute. And I'd like to thank you all very much for coming. But before that, I would like to thank Judge Spanó and Lord Sumption for their very interesting, very well-informed and stimulating remarks. Thank you both very much.